This doctor destroyed me on cross-examination. He destroyed my entire cross-examination. And how did it make me feel? It made me feel like... You want to learn what this is all about? Come join me for a walk through the neighborhood as I tell you exactly what this is all about. Hi, I'm Gerry Oginski, a New York medical malpractice and personal injury attorney. This happened many years ago when I was first starting out my career as a plaintiff's attorney, a lawyer who represented injured patients in medical malpractice cases. I thought I knew how to do cross-examination. And you know what? I thought I was pretty good at it until I met this doctor. Here's what happened. We're in the middle of a medical malpractice trial. The defense brings in an expert on behalf of the hospital to say that the hospital and their staff did absolutely nothing wrong. They brought in a doctor, an emergency room doctor, to come in and testify on their behalf. Now, the defense attorney had an opportunity and did question their medical expert for about 2 hours. And this is known as a direct examination. And the purpose was to acclimate, to get the jury to understand exactly what was done from the defense's standpoint, to make them realize that what they did was absolutely appropriate. So now, after the defense lawyer is done questioning his own medical expert, the jury is eating this stuff up. It is now my turn to go ahead and cross-examine this witness. The judge turns to me and says, "Mr. Oginski, you may now inquire." I proudly get up, I strut in front of the jury, and now I begin my attack. I begin my cross-examination. And from the moment I started, I was dead in the water. What happened? I'll tell you what happened. When I asked the doctor simple questions that called for yes or no, you know what the doctor did? He gave long-winded answers. Like, wait a second, why is he giving a long-winded answer when I only asked for a yes or no? So I did it again. I asked another simple yes or no question. I asked a simple yes or no question, and instead of giving me a simple yes or no answer, what did the doctor do? He went ahead and gave a long-winded answer. And I'm wondering, holy cow, how do I stop this guy from going ahead and giving these long-winded answers? The jury is eating up what he has to say. He's got total credibility right now in front of the jury. I'm not doing anything to try and drop and diminish his credibility. This is bad. This is really bad. No matter what question I asked, this doctor was so savvy that he would go ahead and give these explanations. Doctor, I just asked you a simple yes or no question. Well, I can't answer it just yes or no. I have to give you an explanation. Doctor, did I ask you for an explanation? And now, what am I doing? I actually started arguing with the doctor about how he should be answering the questions. And then the defense attorney would jump up and he'd say, "Judge, he asked him the question, let the doctor answer the question." And the judge would agree. "Mr. Oginski, you opened the door, you asked the question, now let the doctor answer the question." The judge wanted to know the answers. The defense attorney wanted to know the answers. The jury, I could see, was paying very close attention, sitting on the edge of their seat. They wanted to know the answers. And I knew I was dead in the water. Why? Because this doctor was playing me. And I had no clue at the very beginning of my career how to control this witness. I had heard about asking only yes or no questions during cross-examination. I had heard about keeping a doctor, especially one whom I'm cross-examining, on a very short leash. But I didn't understand fully how to actually accomplish that. So now I'm getting very frustrated. And that frustration is turning into anger. And that frustration is turning into arguing with the doctor that the doctor's not answering my question. At one point, I did something that a rookie attorney should never, ever do. No attorney should ever do it. I actually turned to the judge for help to control this particular doctor. "Judge, the witness is refusing to answer my question, yes or no." Well, and what did the judge say? The judge said, well, if he can't answer it yes or no, and this is the only way he can answer it by giving an explanation, then I encourage him to give an explanation. I'm like, "Judge, you're not helping my case." The reality is that the judge is not there to help my case. My goal is to go ahead and try and establish contradictions in this doctor's testimony, to show that this doctor is a hired gun, to show that this doctor is biased. And you know what? I was having difficulty doing any of those things. Why? Because I could not control what this witness had to say. And every time I tried to interrupt the doctor as he's giving these long-winded explanations, I kept getting objected to by the defense lawyer. The judge kept telling me to stop it and now to allow the doctor to continue answering the question. And now I'm stuck. I'm stuck asking a question. The doctor's not giving me the answer I want. He's giving long-winded explanations. I'm stuck in the back of the courtroom. The jury's not paying attention to me. They're paying attention to the doctor. And now I'm wondering, how can I get out of this? The sad reality is that I was not able to get out of it. But I learned a valuable lesson that day. The valuable lesson was I was unable to control this witness. It turns out that this witness had been in the business, in addition to treating patients for a 25-year career, had also during that same period of time been in the business of reviewing medical records on behalf of doctors and hospitals who were sued. And he also made a career of testifying, coming into court over and over and over again on behalf of those doctors and hospital staff who were sued. So this guy had been in the court many times. He was what we call a frequent flyer and knew the system very, very well. He knew, and I'm sure his attorney had prepared him before testifying, that if at all possible, to go ahead and do everything he can to explain his answers. And knowing that I was a young novice attorney, he had no problem whatsoever following through on that. I, on the other hand, had no clue, had no idea how to actually control this witness. I'm happy to report that since that time, that valuable lesson has served me actually very well, because I since have learned how to control witnesses, hostile witnesses, witnesses that are refusing to answer my questions, refusing to answer simple yes or no questions. Instead, witnesses who choose to argue with me and to try to show the jury that they're being reasonable by giving long-winded explanations of how they're right and we are wrong. One of the best ways to do that, and I learned this from a number of excellent trial attorneys, is to establish ground rules at the very beginning when I get up to cross-examine. So here's what I mean. One of the ways to control a witness like this, especially one who's been on the witness stand before and knows exactly what to do, is to lay the ground rules. Hey, Dr. Jones, my name is Gerry Oginski. I represent the injured patient here. We've never met, have we? No, we haven't. Before I get started in asking you questions about this particular case, I'd like to ask you a series of questions. And if you can do your best to answer them, I'd appreciate that, okay? Yes, of course. If I ask you a simple question that calls for a yes, do you promise to tell me that the answer is yes without giving me any explanation? Why, of course, yes, I'll do that. And now, doctor, if the answer is no, do you promise to give me that answer without giving me any explanation? Yes, of course. And doctor, if you don't know the answer, do you promise to tell me that you don't know the answer without giving any other information? Of course, I'll do that. And doctor, if you are unable to answer my question for whatever reason, do you promise to tell me that you can't answer the question the way I've asked it without giving me any additional information? Yes, of course. Now, why would the doctor agree to those things? Because at the very beginning, he still wants to appear reasonable to the jury. He has not offended them yet, and I have not gotten into an argument with him yet. So now he's coming in as the authority. He's got all the credibility after having been questioned by his own attorney. Now the jury still trusts him, and he's still being agreeable and amenable to these simple ground rule instructions. Doctor, isn't it true that Mrs. Gold came to your office on January 1st? Why, yes, that's true. Isn't it true that when she came into your office, she complained of having a lump in her left breast? Well, no, that's not true. Doctor, isn't it true that when she recorded information that your office provided to her about why she was there, what her complaints were, she wrote down that she had a complaint of a lump in her left breast? Well, let me tell you what that really meant. That's not really what it's... Doctor, let me take you back to the ground rules that you agreed to a moment ago. If you are able to answer the question yes, you promise to answer yes. True? Yes. If the answer is no, you promise to answer no. Isn't that right? Yes. If you could not answer the question, you promise to tell me that without giving me any additional information. Isn't that right? Yes. Now, doctor, I asked you a question about whether the information that Mrs. Gold provided to your office in the paperwork she filled out while waiting to be seen indicated that she had a complaint of a lump in her left breast. Isn't that true? Well, no, that's not exactly true. Let me tell you why. Hold on, doctor. Did I ask you to tell me why there might be a discrepancy into what she wrote and what she actually complained of? Well, no, you didn't. Okay, doctor, so let's go back to the question I asked at the beginning. And now, what am I doing? I am controlling this witness's testimony based upon the simple ground rules that I laid out for him, that he readily agreed to before I started asking him questions. And now, as a result of that, I was the one in control. I was the one controlling the conversation. I was the one who decided what questions to ask, and I no longer had to turn to the judge for help and say, Judge, the witness is refusing to answer my question yes or no. How can you help me control him? I no longer had to do that. Why? Because now, if the doctor chose to go ahead and deviate from those ground rules, now he was the one who looked unreasonable. Now he was the one who was trying to get information in that clearly he agreed not to provide. And by doing this, by doing these simple ground rules, Now I was able to establish control, and guess what? One last bit of information. Many years later, I had another case that went to trial, and who do you think the expert was? The expert in this other case many years later was the same emergency room expert that I encountered very early in my legal career. And now he was coming in again on behalf of the hospital, and I knew his shtick. I knew exactly what his game plan was. And so what did I do? I used the method that I just described in order to control his answers and to control this witness's testimony. And that worked. It worked beautifully to the point where this doctor was unable to go ahead and explain any of his answers. Now, of course, you should know that when I was done with my cross-examination, his lawyer was permitted to get up and to ask him additional questions, known as redirect examination, to go ahead and explain away anything that I would not allow the doctor to go ahead and explain. But the point is, I learned a valuable lesson that day. That day, I couldn't figure out how to control this witness. Years since, not only did I learn how to control it, but I learned how to do it quite well, so that many years later, when I had the opportunity to come up against this doctor again, I used that exact strategy with him, and it worked beautifully. You know, I realize you're likely watching this video because you have questions or concerns about your own matter. Well, if your matter did happen in New York, and you are thinking about bringing a lawsuit, but haven't done so yet because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.